I'd now like to introduce our first keynote speaker, Michael O'Connell. Michael is the Commissioner for Victims' Rights in South Australia. He's the Secretary-General of the World Society of Victimology, and he also lectures and writes on victimology and criminal justice in Australia, but also overseas. Michael was previously appointed as South Australia's first Victims of Crime Coordinator and was the inaugural Victim Impact Statement Coordinator. Prior to those positions, he had served for over 20 years as a South Australian police officer. In 1995, he was awarded the Australian Police Medal for his work on victimology. In 2003, he was a finalist in the South Australian State Competition for Australian of the Year 2004. And in 2010, Victim Support Australasia presented him with its National Award for advancing victimology and promoting victims' rights. This evening, Michael's going to speak on the topic, Challenging Orthodoxies, Victimology, Victims' Rights and Victim Assistance. Please join me in welcoming Michael.
The whisper was a casual warning that I should keep on time. He's obviously heard me speak before. I could begin my presentation this evening with just the simple word ditto and walk away. One of the reasons that I feared that I may be repeating some things to you is that I chose to create a different slide for you to look at. Let me begin by echoing the greetings that have already been extended to all of you, and also paying my respects to the original owners and custodians of this land. An orthodoxy is an authorised or generally accepted doctrine, practice or theory, a belief or way of thinking. So this symposium is about challenging our doctrines, our practices, our theories, our beliefs and our ways of thinking. One way to understand the rules or laws and institutions such as the criminal justice system in a particular place is to examine their genesis, where they came from, what was used to create them, what conflicts were present at the time, and so on. As laws are forged and institutions established, various interests jostle for influence and seek to ascend to a dominant position. Professionals such as lawyers and academics such as victimologists are among those seeking such positional power, and NGOs such as those associated with the so-called Victims of Crime movement can be added to the mix. The capacity to dictate to which, to what, to whom currency is given is the success sought. On the other hand, those who hold power do not surrender it readily. Those who helped create our criminal justice systems, for example, often seek to ward off scrutiny of those rules and laws they hold dear, that is, that they see as fundamental. They also seek to largely maintain the status quo or endorse reforms that buttress their positional power. There is an inherent risk when seeking to promote or attain prominence for a new orthodoxy that one can be consumed by existing forces, somewhat like being sucked into a black hole of power. Thus, the objective of attaining a just, fair and equitable justice system for both victims and offenders might be overwhelmed by reforms that unduly impact on the rights of all citizens presumed to be innocent. Scholars such as Richard Harding, for instance, have warned that elements of the victims' movement have already been swept up by the law and order lobby. Conversely, non-government organisations and advocacy groups, drawn together by common aspirations and shared interests, have proven it is possible to avoid co-option and/or consumption, as well as show it is possible to promote progressive causes that transform criminal justice. A prime example of this is the International Criminal Court, in which, I hasten to add, victims are legitimate participants. Another example is the way significant inroads have been achieved in advancing victims' rights in, for example, the USA. The President Task Force, pre the President Task Force, some lawyers attempted to attain legal standing for victims in criminal proceedings. Superior courts, however, held that the victim does not have such status in adversarial common law criminal justice systems. However, and I emphasise this, that could change if the legislature enacted the appropriate law. While lawyers were fighting in courts, the victims' movement was gaining momentum, and academics' research was tackling misconceptions and building a better victim-informed knowledge base. Their collective power has had substantial influence, and a similar story can be told about reforms in Japan and elsewhere. But that story is incomplete. The victims' movement is not a single force, neither are victimologists. Among the latter, challenging orthodoxies is an essential ingredient of victimology as a science. The early victimologists, for instance, challenged the one-sided view of crime that focused on the criminal. These victimologists raised questions about victims' role in their demise and suggested some victims might precipitate their victimisation and might even be culpable. The notion of victim precipitation attracted much criticism from feminists who pointed to it as victim blaming, to say the least. In other words, feminist interventions challenged the orthodoxy of victim culpability. More recently, feminist interventions are challenging restorative justice and transitional justice. Regarding restorative justice, questions have been asked about the power imbalance between the victim and the offender, and concerns have been suggested about victims' safety. Victimologists who helped draft the Model Convention on Justice for Victims of Crime and Abuse of Power noted such concerns, so the Convention provides for restorative justice, but only if the victim chooses, only if the program is conducted in a manner consistent with victims' rights to, for example, be treated with respect and dignity, and as well that the programs ensure that victims' safety is paramount. Critical victimologists have also revisited fundamental assumptions regarding human rights and the role of legal processes, truth commissions and the like in advancing justice struggles. They have pointed to the need to pursue accountability for instance, mass atrocities, particularly violence perpetrated on women and children. Lessons learnt and critiques proffered are helping, perhaps not enough, the work being done in societies emerging from repressive rulers or armed conflict. Perhaps such unwillingness to accept the beliefs and rationales that underpinned early forms of transitional justice will lead to better interventions in society where historical injustices or systemic abuse are yet to be resolved. My point is that challenging orthodoxies about victimisation is a means to improve plights of victims if such challenges are properly informed. Properly informed can make the intervention a powerful tool. That said, as an issue for consideration, I posit this thought. If the victims' movement is seeking to have a system that is more respectful, more dignified, more compassionate, that is just, fair and equitable, then it seems paradoxical to be lobbying for laws, policies and practices that treat another human being, the suspect, the defendant or the offender, in contrary ways. Victimologists, as I said, have studied the relationship between the victim or victimal and the perpetrator or criminal since the 1940s. Since then, a recent Australian Institute of Criminology report points out, and I quote, certain aspects or types of victimisation have received particular attention. The author of the report states, and again I quote, it is accurate to say that the experiences of victims and the study of victimology, and I add particularly in Western countries, has been rather limited in its scope and its depth. Ellis, for example, similarly highlights the paucity of information founded on scientific principles with respect to male victims of rape and secondary victims of, for instance, sex offences. Elsewhere, I have commented on the shortfall of our knowledge regarding victims of white-collar crimes. What is known suggests that in terms of mental health issues, some victims of white-collar crimes suffer disorders similar to victims of violent crime, including victims of sexual assaults. In the USA, a decade ago, Andrew Carman added that over 24 crime victims types have been overlooked in the mainstream victimological literature. Georgina Fuller, the author of the report I just cited, warns that such omissions are, and I quote, potentially detrimental to the understanding of victimisation. Furthermore, the risk then is that services and legislation based on research that focuses on a small minority or particular type of victim will not be able to be broadened to the wider population. End of quote. Despite this gap in our knowledge, there is a consensus that social, health and welfare services are necessary if the needs of victims of crime are to be properly met. That said, in too many places, there is inadequate scientifically valid evidence to show whether the various victim assistance programs are meeting victims' needs. The one-shot surveys are useful, but also unsatisfactory in yielding the kind of knowledge required to ensure such programs are well designed, properly implemented, and most importantly, matched to victims' needs that change over time. USA research reported a mismatch between victims' needs and a range of services provided by victim support agencies, which the researchers attributed in part to the dominance of the social work paradigm. British research found a mismatch between a range of services offered by Victim Support UK and the expectations of some victims. Victim Support UK began as a program to help burglary victims, but expanded to cover all types of crime victims. The researchers suggest the assistance gap might be a consequence of the manner in which Victim Support UK evolved, from a localised organisation helping victims of, as I said, burglary, into a national organisation endeavouring to cater for all victims' divergent needs and interests, yet remaining attached to its traditional ways of doing business. Findings in Australia indicate a similar mismatch. For example, in one state, a survey revealed only 4 in 10 victims were satisfied with the victim support service received. Victim respondents in another survey who identified a preference for a particular type of assistance focused not so much on emotional and psychological needs, but on practical needs, such as help to prevent further crime, assistance dealing with insurance companies, and legal advice on entitlements. In addition, victims of theft wanted their property returned or replaced. Families bereaved by homicide failed to comprehend why they must prove they suffer pain and anguish as well as grief in order to receive state-funded victim compensation. More recent research showed 6 in 10 respondents from South Australia and Western Australia who had sought assistance did so to receive support with their role in the criminal justice system, including assistance in preparing for court and/or help with understanding the criminal process in particular. Many of these victims had no experience with the criminal justice system, so they wanted information on their role and responsibilities, which notably is a right in at least one of these jurisdictions. About 1 in 5 victim respondents wanted help with specific aspects of the process, such as referral to legal services, an issue I'll return to later, help obtaining information from the police or other authority, assistance completing victim impact statements, and help applying for restitution from the offender or compensation from the state. Although some victims sought counselling or psychological assistance, more commonly they wanted the opportunity to talk about their experiences with other people who had experienced similar crimes. When all responses for those who mentioned support or emotional impact were combined, only 1/2 of victim respondents who had dealt with a victim support service had done so primarily for assistance with the emotional effects of the crime. This ongoing debate on the mismatch between victims' perceived needs and victims' real needs is used by some as a valid reason to shift away from state-funded victim compensation schemes towards financial assistance schemes that might, proponents say, better cater for victims' practical or material needs. State-funded compensation as a concept to right wrongdoing can be traced to the Hammurabi Code some 4,500 years ago. In accord with that code, if a robber was apprehended, the local community was obligated to replace the goods or compensate the victim. The modern concept of state-funded compensation is attributed to British magistrate Marjorie Fry, who was incensed by the shortcomings of offender-paid restitution. Her plea for the state to compensate victims of crime, especially victims of violent crime, was first taken up in New Zealand in 1964, and like schemes were introduced in Britain, the USA, Australia and Canada, among other countries. Like schemes are also provided for in Asia countries such as India, but I understand few of the provincial governments have implemented such. In contrast to restitution and civil litigation, the state, not the offender, pays compensation in such schemes. Although these schemes are popular responses, they are not without their critics. Some say there is no justification for treating victims of crime differently from victims of other misfortunes. Some say there is no rationale other than that the state presumes for such compensation. Conversely, others hold that the state's duty to help is consistent with the notion of the social contract. Others look on such compensation as justified social welfare, whereas others point to a humanitarian ethic. And a South Australia court once described state-funded victim compensation as, and I quote, an act of grace. The main difficulties of such compensation include that few victims know about them and few apply, that is, relatively speaking. Paradoxically, when victims' numbers accessing compensation schemes increase, the major objection, that is, the rationale often for amendment, is financial. It is also an impediment to broadening the coverage of such schemes. Indeed, in some places, it has become a reason to reduce eligibility. Certainly in places where compensation has been cut, it is unclear what the long-term impact on victims' well-being has been. In places where financial assistance has replaced compensation, it is evident that governments have made savings, but it is not evident whether victims' real needs are better met. Recent media reports in one Australian state suggest victims are dissatisfied with the sums paid as assistance and as acknowledgement for the harm done. And victims who once were eligible for compensation but now denied financial assistance feel much disenfranchised. I have no fixed view on the debate, given our knowledge is so sparse. It makes no sense, however, to ignore victims of crime in reforms such as those happening. I will add at this juncture that the United Nations Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power stipulates that victims have a right to seek restitution from offenders, and it obligates states to pay compensation to victims of violent crime if restitution is not available. Unlike many state-funded compensation schemes, restitution requires conviction of the offender and rests on the offender's ability to pay. Restitution is today considered in many places to be a criminal sanction, yet it is often not used or enforced because courts and others view the bulk of offenders who are prosecuted and convicted as being without the means to pay the victim. In the United States, New Zealand and Australia, victims have expressed their sense of frustration resulting from either the failure of courts to make restitution orders or the failure of offenders to pay. Another grievance arises when the recovery of the debt to the state is seen as a priority over restitution for the victim. Perhaps, and this is a suggestion for consideration, Offenders, whether in prison or serving non-custodial sentences, should be required to work in a national correctional-based industry program to earn money to pay restitution to victims and not debts to the state. Regarding the state's monopoly on criminal justice, I turn now to the rights of victims of crime. In most civil societies, the state, not the individual victims, brings criminal proceedings on behalf of the public at large, that is, society. In earlier societies, victims and all their families and kinfolk were responsible for righting wrongdoings, for avenging harm done to them by offenders. In Britain, the home of the common law adversarial system that many countries have inherited, avenging harm by a blood feud was replaced by private prosecutions and next public prosecutions. Righting the wrong to the victim was, as a consequence of the transition, replaced by punishment in the instance of the state and rehabilitation of the offender. This fundamental shift from private justice to state justice was inspired by Enlightenment commentators and facilitated by people's preparedness to entrust the state with such responsibilities. As the state's power to administer criminal justice grew, so too did the reliance on professionals. Privately paid police were replaced by publicly paid police. Privately paid prosecutors were replaced by publicly paid prosecutors. By the 20th century, the victim had been relegated to a witness for the state as investigator and as prosecutor, as well as jailer. The criminal justice system, observed Lewis Hite, began to serve police, lawyers, judges, and defendants, while treating the victim with institutional disinterest. Victims' tales about police ambivalence, prosecutorial indifference, and courts as being places of trial by ordeal became common. It became cliché to claim that the victims were forgotten in our criminal justice systems. Certainly, victims who once controlled criminal justice have been disempowered, no longer a party, no longer an active participant in key decision-making that affected them. The call for victims' rights seeks to remedy this situation. The call was magnified by a sense that victims' rights would be just, fair and equitable to those who were harmed. Initially, victims and their advocates wanted the victim to be kept informed about investigations and the prosecution and to be told about court outcome. They also wanted the right to be protected from unnecessary intrusion on privacy and to have their safety concerns attended. They sought reform to engender respect for their dignity and compassionate treatment by police, to humanise prosecution and criminal proceedings, and to strike a balance between the rights of victims and the rights of defendants. As Baroness Newlove said a few days ago, victims wanted respect for their rights to become the norm and not the exception. And that's just paraphrasing her. And I quote, she went on, "Rights for victims should be our first thought, not an afterthought." Victims' rights instruments in international, regional and domestic law and/or policy are intended to empower victims and to obligate police, prosecutors, magistrates and judges, correctional officers and others. The United Nations Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power, the 30th anniversary of which is celebrated this year, as pointed out by a previous speaker, enshrines 10 fundamental rights for victims of crime, which are a mix of negative rights and positive rights. The former prohibits certain actions. For example, public officials should not unnecessarily intrude on victims' privacy, whereas the latter require the provision of certain actions. For instance, governments should provide material and therapeutic assistance to victims of crime. Furthermore, when enacted in domestic law, these rights are frequently constructed as passive rights. So victims are required to, for example, ask for information about the investigation before a police officer is obligated to provide it, or ask to be notified on prosecutorial decisions before a prosecutor is obligated to consult. Service and informational rights have been widely welcome, perhaps because criminal justice agencies have realised, with some degree of self-interest, that being seen to be victim-oriented might help them in getting greater cooperation of victims as witnesses for the state as prosecutor. On the other hand, participatory rights are said to be fraught with difficulties, especially in adversarial criminal justice systems. Indeed, a court in a country with an adversarial system observed that in such jurisprudence, a private citizen lacks a judicially cognizable interest in the prosecution or non-prosecution of another. But I respectfully assert that the tide is turning, which is a matter I'll turn to shortly. Before doing so, I want to make a few observations on the operation of victims' rights instruments. An evaluation on the implementation of the UN Declaration and studies on the effectiveness of domestic victims' rights instruments in several countries reveal that, in spite of better recognition of victims' standing in criminal proceedings and improvements in their treatment, too many victims continue to be denied their fundamental entitlements. Their interests, in addition, remain peripheral to those of the state and those of defendants. As a consequence of such, demand for stronger and enforceable victims' rights has gained traction. Such rights have been enacted in the United States and promised in other places. Victims standing as participants in criminal proceedings, as I mentioned, in the International Criminal Court and some international tribunals. In Austria, victims' rights to legal counsel have been reintroduced, and in Japan, crime victims, like those in Germany, have become co-accusers. Independent statutory officers have been established in Britain, Canada, and the United States, who, among their functions, inquire into victims' grievances and recommend remedies where there have been violations of victims' rights. A US study, however, suggests that stronger rights do not necessarily produce better outcomes. Perhaps instead of stronger rights, should be greater investment in the current regime of crime victims' rights. Indeed, Professor Grönhausen says, and these are my words, not his, that it is ludicrous to assume that if public officials are already not meeting their obligations, that simply increasing their obligations will improve the operation of victims' rights laws. It is also unclear whether victims genuinely benefit from the rights industry and the culture it fosters. Some commentators, for example, allege the victims' rights agenda has, as I said previously, been co-opted by the law and order agenda. Others point to crime victims' unrealistic expectations, which might be driven by the vested interests, such as lawyers who profit from victims attaining legal status in criminal proceedings. While another commentator warns that victims' rights should neither be the sole preoccupation nor a distraction if, and I quote, the dynamic between victims and victimisers and the social, economic, political and cultural context is taken into account. The concept of victims' rights, I suggest, remains contentious, and the growth of enforceable victims' rights is, I concede, not yet well informed. That said, the genie of victims' rights is out of the bottle and unlikely to be returned. Giving victims' rights, especially participatory rights, can alleviate their sense of disenfranchisement and prevent secondary victimisation. Thus, ensuring victims throughout the world are treated fairly and equitably, as well as have access to justice, is paramount. In terms of challenging orthodoxy then, where to next? It seems to me that victims should have the right to be heard at various stages in the criminal justice process. This right is critical to ensuring that victims' voices are integrated into the very fabric of justice. The criminal justice system should not be blind to such right. A significant re-engineering of our criminal justice system is needed. As Marlene Young said in 1984, the demand for victims' rights requires no less than a new jurisprudence. For this purpose, criminal proceedings should be a tripat, or, as Lord Stein suggested, be about a triangulation of interests: the victim, the defendant, and the state. Victims should be active participants, represented, in my view, by lawyers, which, if they cannot afford, should, consistent with the UN guidelines on legal aid, be paid for by the state. And criminal proceedings should, to improve efficiency, reduce court delay, and to alleviate the burden on the victim, be both a place for criminal sanction and civil judgment. Victims deserve more than symbolism. Victims' rights should be mandatory obligations for action. To rebalance the discretions exercised by public officials and the conceived bias in procedural justice that favours defendants in our criminal justice systems, I suggest there are several possibilities, and I turn to but one. The victim could hire counsel and assume the role of a co-accuser or co-prosecutor. This counsel might assist victims dealing with police, such as is now proposed to happen with victims of domestic violence in South Australia, and engage in deliberations with prosecutors. This counsel might assist victims' representations at pre-trial hearings, which would avoid contaminating the victim's evidence should the matter go to trial. This counsel could be available for victims to posit their concerns without fear of disclosure, given the legal privilege that would exist. This counsel could ensure victims' rights are protected during proceedings. For instance, object to unscrupulous questions, maintain the integrity of protected communications, and assist victims to make victim impact statements. This counsel might also, by means of a writ of amidanus or similar, seek judicial review if the victim was, for instance, not notified as required under victims' rights instruments, or not consulted before charge bargain decisions are made. Well, we've not quite achieved that, not anywhere in Australia, but as Commissioner for Victims' Rights, I have some powers consistent with these tasks that I suggest for legal counsel. I can assist victims dealing with the criminal justice system. I can exercise victims' rights on behalf of individual victims. I can engage legal counsel to assist me exercise my powers. Furthermore, I can represent victims' families bereaved by homicide in hearings to deal with the proclamation of dangerous offenders. And I can represent victims in general in hearings seeking sentencing guideline judgments. I also can make victim impact statements, neighbourhood impact statements, and uniquely to South Australia, social impact statements for individuals and collectives of victims. The Supreme Court of South Australia has, in addition, as a result of my interventions via legal counsel, allowed victims to cross-examine witnesses in limited circumstances and to make submissions on whether to release a persistent sex offender. Contrary to those opposed, these interventions have not brought the criminal justice system crashing down. Rather, I assert, they have enriched that justice system. I close on a reflection attributed to the famous detective Sherlock Holmes, who this year we celebrate the 50th anniversary of the death of his creator. And in a story called The Last Bow, which is written just as the First World War begins, Holmes turns to Watson and suggests that there is an east west wind coming. Watson observes that he cannot feel that wind, and Holmes rebukes, saying, "One of the things about you, Watson, is that you are staid and unchanged." But I respectfully suggest, as did Holmes to Watson on that day, that change is inevitable. And after much heartache, distress, and the many challenges that we as victimologists, victim advocates, victims and others confront, that a new order will arise, and that order will be just, fair, and equitable. Thank you.